the Supreme Court agreed to hear a challenge to the EPA's authority to regulate power plant emissions. Now, okay. I would just explain something about the Supreme Court. I saw some, I don't want to get into a back and forth about it, but I saw somebody who had done a commentary on a clip that we did about somebody had called in. I can't remember who the guy was, some libertarian or something like this, had called in about Citizens United. Mm-hmm. And the commentator who was looking at it said, like, Sam and Emma doesn't know what Citizens United about. It's about advertising, political advertising for a political documentary. The facts of the case in Citizens United were, yes, that there was a group that wanted to advertise a documentary they had made. I think it was like a, anti-Kerry or anti-Clinton. I can't remember.
Hillary Clinton.
Anti-Clinton. And they wanted to advertise. Those were the facts of the case. That is not why Citizens United is an important case. And that is not what the case is about.
Yes. I wrote my senior thesis on this very topic. So libertarian caller, you do not know as much about it as us.
Well, it was actually a sort of a left-leaning commentator who was making this point.
Oh, sorry.
Who did not seem to understand that the reason why Citizens United is important is not because it's about advertising. If the case was solely about, should you be able to advertise a political documentary, then Citizens United would never be talked about. What Citizens United, what the Supreme Court found. A
left-leaning commentator makes this. Okay.
What Citizens United, the essence of that case, the importance of that case is that the Supreme Court found that not only was it okay for you to advertise a political documentary, but that the federal government had no right, and it was an abridgment of a constitutional right of speech, for the federal government to restrict in any way corporate spending on electioneering. That's the whole point of Citizens United, not the advertisement. The point is that the Supreme Court used that as an opportunity to say the federal government does not have the right, not only to say within 60 days of an election, you cannot pay for something that is electioneering, et cetera, by a corporation, but rather that the federal government had no authority in any way to abridge the expenditure of electioneering money by corporations. That is the essence of Citizens United. Just like in this case, it's not just simply whether the EPA has the authority to regulate power plant emissions. It is whether ultimately Congress has the ability to pass a general law that can delegate the authority of making the specific assessments to executive agencies. So in other words, Congress writes a law that says,
regulate this coal plant.
No.
Or no.
Congress writes a law that says Americans deserve clean air.
Okay.
We delegate the authority to the EPA to assess what constitutes clean, healthy air, and what's the best way to achieve that. Because Congress does not have the ability, because they're not scientists and they're not in the business of constantly updating, to assess what is in the air and what that might do to human beings long term.
So they delegate the authority to the EPA for them to determine what's the best way to do
what's the best way and what's the most dangerous elements in the air.
Yeah.
And I mean, there was a time where we were not aware that lead gasoline puts lead in the air, and that could be a problem. And if Congress was necessarily had to, guess like what's in fracking fluid, we don't know.
Let alone all of the corruption issues that are involved in the way that Congress might be writing legislation if the EPA does not have the authority to make these determinations.
I mean, frankly, the EPA has its own corruption issues with this as well.
Well, they're already, I mean, Republicans are already trying to like stack political actors in the EPA and get rid of experts as well.
There's been real problems at the EPA.
This would open the floodgates.
But the corruption is, I think, less the problem as much as like there's only one way for this government to function if the government has decided that they want to make sure that food is safe for human beings, that air is breathable for human beings, that broadly speaking, we don't want predatory practices by financial institutions. We could go on and on and on because every single, the way our government works, there was an analysis that was done. I don't know if oh yeah, here it is. Okay. So this is an analysis that was done by the Washington Post. And this is a case, remember now, the Supreme Court took this case, the non-delegation doctrine was held by the Supreme Court back in the beginning of the 20th century. And it goes along with the Chevron doctrine, which says that unless Congress is specific, courts must defer to these agencies' expertise. So there are two different things that are working here, which allow Congress to broadly say to the executive agencies, we want you to broadly do this. And you guys are the experts. You figure out how to best achieve these goals. We give you the broad goals. We want safe drinking water. We want clean rivers. We want clean air, healthy air. We want healthy food, et cetera, et cetera. And according to this Washington Post analysis by Pamela Klauser-McCann and Charles R. Shippen, they found that the founders themselves often delegated authority to executive agencies, indicating they believed delegation was consistent with the Constitution. There was a period in this country, 20s, 10s, 30s of the 1900s, that the Supreme Court espoused this non-delegation doctrine. Remember, that court was incredibly regressive. It also allowed for all sorts of voting restrictions.
That was also child labor laws and
yes,
that regressive period.
So, and this is going to have broad implications. And so they did a study to find out. They began with a well-known list of major statutes, 443 of them that were passed between 1947 and 2016, passed by Congress to establish how operative would those statutes be if the Supreme Court decided to readopt a non-delegation doctrine. They wanted to assess based upon they did some thing. I'm not going to go into it, but they basically cross-referenced some databases. They wanted to identify all agencies that drew statutory authority for the rules and regulations from each law, so that they can infer which statutes delegate policy-making authority to these agencies. What percentage of major laws delegate? The answer is more than 99% of them.
Whoa!
Basically all of them. Only 4 of the 443 laws they examined did not delegate any authority to government agencies. And one of those, the Partial Birth Abortion Ban Act, delegates policymaking power to the states. Furthermore, most of the laws delegate to several agencies. Nearly half delegate between 2 and 5 agencies. Another third delegate to more than 5. Here's the point, is that if this Supreme Court, and this is their first opportunity with their 6-3 majority, if they reestablish, essentially recreate a non-delegation doctrine, virtually all of the functioning of agencies will be hampered. Virtually all of the ability of Congress to pass laws that protect workers, consumers, children, parents, citizens, animals, air, water. I don't know. What else is there?
Yeah.
That allows you to have the internet. I mean, whatever it is will be decimated, undermined. It'll take time for each one of these things to be undermined because it'll be just a function of the corporations coming in saying, you can't do this.
Yeah.
You can't. You don't have the authority. And so then Congress wants to regulate us putting in tetrachloroethylene into the water, whatever it is, this new, chemical we made up. They have to go back and they have to legislate specifically for that one chemical into maybe specific size water bodies, right? Because Congress said they don't want it in rivers, but they didn't say anything about ponds.
Yeah.
They didn't say anything about the ocean. This is a real problem. And, short of the guests that we've had on this program to talk about it, it's completely obscured. And it could be really massively, problem. Just crazy. So that and the deer getting COVID. Have a good day, folks.
Yes. I wish I had something to add, but you.
Did it make sense what I said?
It was, yeah. I don't like complimenting you, but
I appreciate that.
Yeah, it was well said.
No, you're not the only person in that situation. I can assure you.
It's interesting that literal mindedness. You see a lot from libertarians about this was about an advertisement. But that's not how law works. There are larger ramifications.
Yeah.
Right.
This is
right.
ABCs.
Right. That's the thing is that the sort of the you really need to read more than just Wikipedia to understand sort of the implications of these things. You don't have to read a lot more than Wikipedia, but you need to read more than Wikipedia.
Yeah, well, like free speech literalism.
Literalism is designed to be to uphold norms and to essentially obscure larger truths.
And this is of I understand that, obviously, ripping the rights of women for self-determination of their body is a paramount issue when it comes to the Supreme Court, and
Right.
it's certainly something that I think that regardless of what happens with Texas, we're going to see in Mississippi this right continued to be sort of abridged, in my estimation.
I would guess that they side in that sweet spot.
Yep.
Well, not so sweet, but the 15-week Mississippi
And
law.
then it'll be 10, and
Yeah.
then it'll be 6. It's just a matter of time.
Once you abridge Roe, it's very easy to continue doing so. No rhyme intended.
But in terms of the way it's going to impact people's lives in every state in the country, this non-delegation doctrine could be more problematic. It's not something that Democrats can run on, it seems to me. But
yeah, and it's going to get a fraction of the attention, and that's the issue there as well.